Okay, I'm unmuted. Welcome everyone who has came in. Hey, Miss Dominique, how are you doing today? We'll get this music stopped here in just a second, and we will get going. All right, let's get some graphics up on screen here. We're gonna start by taking a look at some things that are going down before Monday's the beginning here of the Delphi hearings, which will commence Monday, as the judge handed down a decorum order yesterday. In this case, and this is this one of the sites that I've really been using to keep up with a lot of things. The 21 Alive News. Excuse me. So the judge hands down courthouse management decorum order ahead of Monday's Delphi murder case hearings in Allen County. They are out of Fort Wayne. So what's going on, Zhukov? If any of you guys have been following what's been going on in Delphi, well, the tragedy that's in Delphi, it looks like things are finally starting to get moving. You've had Richard Allen file several attempts to get the case moved out, way out, because the jury pool they were worried would be tainted because of how big the story would be. That was his argument. And also several mental evaluations that were had on him ahead of this murder case. So this came out Friday, and we'll just go over the story real quick here. It says ahead of two hearings in the Delphi murder case set to be held in Allen County on Monday, Allen Superior Court Judge Framgill has set forth the rules and expectations for the day. Richard Allen, the man accused of killing Abigail Williams, 13, and Liberty German, 14, in February of 2017, is expected to be in the courtroom for the hearing, marking the first time that he will appear in an Allen County courtroom. Allen was supposed to appear during an October hearing last year, but did not after the hearing was cut short due to issues stemming from a potential evidence leak. And what had happened there in that evidence leak was an employee of the legal team for Mr. I'm not even going to call him Mr. for the accused leaked out the actual photos of the crime scene, and they were heinous. I don't recommend searching those up because, of course, as soon as stuff gets on Reddit and 4chan, it's going down. Excuse me, but that in itself has been a drama with his counsel, first withdrawing and then having to go through a whole judge approval on should they come back. Excuse me. So the judge's order sets 12 rules and guidelines for the hearing. All 12 are listed below here in the ruling that they have attained. That number one, the courthouse will be open at 8 a.m. All entrances are closed except for the entrance, certain entrances on the building, and those remaining entrances will be locked with no access to the public. All members of the public, including members of the media, are subject to screening by metal detectors. All bag and possessions entering those buildings are subject to search. This is just should really speak to how big this case has been, not just for that community, but nationwide. Of course, no weapons of any kind. They're also banning electronic devices, watches, and whatnot. Looks like preventing building violations are subject to seizure and destruction. So you try to sneak a camera in or recording device, they will destroy that device. Got media personnel are permitted to attend. No cameras, electronic laptops, or recording equipment of any time is permitted in the county courthouse. The court requests the media be mindful that other county offices are conducting business, the building unrelated to this case. Media and members of the public are ordered to conduct themselves in a fashion to limit disruption to the office personnel and patrons of those offices. So they're really going full on with this one. Let's see. The public seating in the Allen Superior Courtroom is limited. The sheriff of Carroll County or his designee will ensure that the victim representatives are seated at the defendant's family is seated in reserved seating in the front rows of the courtroom. That'll be interesting when the families of the victims are in close proximity to anyone that shows up on the accused side. There's been a lot of drama with his wife and family. Of course, no food or beverages are permitted. Excuse me. Water will be permitted for the parties in the courtroom. All members of the public and media are required to follow directives of the Sheriff of Carroll County, the Sheriff of Allen County, Courthouse Security, of course. No court-produced recording will be made available to the public or media. The audio record made pursuant to Indiana Criminal Rule 5 may not be copied or used for purposes other than pertaining to the record. That means we will not get any audio-visual recordings from inside the courtroom on that one. At the conclusion of the scheduled hearing, all members of the public and media will remain seated in the courtroom until court session security releases them. Where they are really clamping on the security on this one. The courtroom will be locked between the sessions of the court. Doors will be unlocked for the afternoon sessions beginning at 1:45 p.m. Court anticipates that all members of the public and media will conduct themselves in an appropriate fashion. Well, that line there, that's going to be hard considering what the man is accused of doing and how big an impact what he did had on the community. Ending the lives of two young ladies who were on the edge of graduating high school and beginning their adult lives. It's going to be hard for you to have to sit there, especially when they start reading off the discovery and list of evidence. So far, the trial is set to begin on May 13th. However, Allen's attorneys, who are the public defenders, Brad Rossi and Andrew Baldwin, filed an emergency motion for continuance Wednesday after filing for an early trial last week. And right here it says that the judge has not ruled on that motion yet. I don't know. I've talked to some people who actually feel that Allen, the accused, may not be guilty in this situation because after the after the leak of the evidence came out and how the scene was posed as very ritualistic, but this has all seemed, they have been the whole Carroll County deputies, sheriff's department, and have all been with it. And really, the most information we've got since the arrest has been made by this Murder Sheet podcast. And if you're interested in this case, I would definitely recommend finding their channel and giving that a listen. But as we mentioned earlier, there was some evidence that was leaked in the case in October of last year. Here, this story here pertains to that. This was around the time where you had his
Delphi
defense team. Let me stop that. Sorry, guys.
Claim they received.
There was some issues with the accused wanting to change his defense team after he claims they weren't giving him adequate defense. So that we're going to talk about that later. We're actually going to get into bar. One of the rules of the bar is 116. That is declining or termination or withdrawing of an attorney to a client. So after some other recent things have happened, I think it would be good to see what the actual rule of law says about that. So I just thought it was interesting now that it's getting time. It's getting down to this court case. All the motions that the defense could file, they've tried. It's all they've tried to move the case. They were worried about the jury pool. I don't know how far out they actually thought they could move this, where you would get a jury pool that, number one, didn't know just a little bit about this case, which I'm sure, of course, there is, but just that they have played it so close to the vest as far as what evidence they are going to have when this thing goes to trial. And I'm surprised that the accused hasn't made some kind of, or his team hasn't tried to negotiate some type of plea bargain behind the scenes. There's a lot of emotion wrapped up in this case, especially after the leak of the pictures that the defense had. Of course, you have to share that with, when motion of discovery is, you have to share your evidence. You have to share, this is what we have. So that's how the defense team even had in possession of those photos. And what had happened was one of the PAs that worked at that particular law firm took his cell phone into the room that the defense team had the photographs laying out on, and proceeded to take pictures of the crime scene, and then went and I think initially tried to sell them, and then at one point it just got released. So I think he was, obviously he was dismissed from the law firm, but that was sort of the last big thing that involved that case, and that was back in October. So we all thought maybe that the hearing was going to start in 2023, but now that we're rolling into this year, here we are in March. It looks like the initial hearings are going to start Monday, with the trial itself proper starting the 13th of May. So that was a little update that had come across my desk there last week. So I wanted to share that. Excuse me. Now we're going to tell the story now. I have been in contact with the mother of a missing Texas teen by the name of Alexandria Joy Lowitzer. And I'm going to get that pulled up on screen for you guys, the FBI poster for that, so you can see that, if you'll give me just 1 second. But I'm gonna get the whole rundown. It's been she was last seen April of 2010. She got off the school bus. There was some people that was the reported that they had seen her, and then that would be the last time that she would be seen. And I'm going to get my screen switched over there in just 1 second, and then we will get into her story. Sorry about this. I'm still a little slow on on the switching between the screens, and people run off because they're like, "Oh, he's so slow." Okay, there we go. And there we go. All right. There is the FBI poster. Let me try to make that bigger for you guys to see before we get into her story here. There we go. Make that down like right there. Okay. Hopefully everybody can see now. If you can't, I'll try to make it bigger for you guys to see on that. And I need to also drop the link in the chat here for anyone who does want to come up. You're more than welcome to. Even if you want to jump back and talk about the Delphi stuff, you're more than welcome. Go ahead and pop that in. So yeah, anybody welcome. There's the link on that. So we are going to tell the story of Alexandria, and then we're going to talk about some of the interesting events that happened here. This case locally, a lot of people are giving the local authorities in Spring, Texas, sort of labeling that as, boy, they just didn't care. They waited too long, this and that. Of course, this is all armchair sleuthing on our end. But here we go. So on the morning of April 26, 2010, started out typical for the Lowitzer family. Like so many mornings before, Allie found herself rushed as she made her way to the bus stop. Allie made it to the bus on time and went on to have a typical day at Spring High School. At the end of the school day, just prior to leaving the campus, Allie called her mother to discuss walking to her new job at the Burger Barn to pick up a paycheck and possibly work a few hours. After begging her mom, Allie's mother, Joanne, reluctantly gave permission for her to walk a quarter of a mile to work after school. The last known images of Allie were captured by the Spring High School surveillance system at approximately 2:25 p.m., leaving the school. The images captures Allie exiting the school bus with others. Images captures Allie exiting the bus with others, 3 houses from her home. A couple of boys got off at the bus at the same time and walked in the direction of their home. They both reported that Allie was lagging behind, but nothing out of the ordinary, but texting on her cell phone. The last eyewitness accounts of Allie state that she was walking away from her home toward exiting the neighborhood. The last communication recorded was a text message sent to a friend at 2:57 p.m. A reasonable assumption would be that 10 minutes of casual walking would put Allie somewhere on the road outside of her neighborhood that leads to the Burger Barn. Joanne, her mother, returned home from work around 5:30. Allie wasn't home, but there was no cause for alarm. She figured Allie would call or message her when she got a break and planned to pick her up at closing time. Not wanting to interrupt her at work with a call, Joanne sent Allie a text around 7 to check up on her. After a while of not getting a response, she sent another message and started to become slightly concerned. By 8 o'clock that evening, Joanne had still not heard from Allie. The Burger Barn closed at 9 p.m., and it usually took about half an hour to close down, so Joanne left just before 9 to see why Allie was not answering and to find out what the problem was with the cell phone. To Joanne's surprise, the Burger Barn was closed, lights out, doors locked when she arrived. This is when the hair on the back of her neck stood up, and she became very concerned about Allie. Joanne immediately contacted other family members, including Allie's dad, John. They began contacting Allie's friends and driving to the houses of friends in hopes of finding their daughter and find out what was going on. This was so not like Allie. Her family and friends spent hours trying to frantically contact and locate Allie with no results. Excuse me. Then her parents contacted law enforcement and reported her missing. They spent the night contacting friends and the parents of the friends. They drive to known hangouts and all around the neighborhood with no results. Allie was reported missing that night. The local precinct came to her home. The officer took a brief look in Allie's room and told her parents to call them tomorrow if she comes home. They told her to call them tomorrow when Allie comes home. Joanne asked the officer, "What do we do if she doesn't come home?" The officer said, "Call us." No report was taken, no advice given that night. The next morning, still no sign of Allie. After an entire day of trying to do all her family and friends could think of, her mom took the advice of her friend at the Girl Scout Council and called the Laura Recovery Center. The next morning, they arrived and helped organize the groups of friends and family and encouraged law enforcement to join in active participation. Law enforcement questioned the boys that exited the school bus with Allie and the employees at the Burger Barn, but concluded that since there was no evidence of a crime taking place, they would classify Allie as a runaway teen. The Lowitzers were devastated. They strongly disagreed with law enforcement, insisting that this was not Allie's typical behavior, and there were circumstances that, to them, did suggest foul play. So that's kind of interesting. So she goes to school. Let's break it down real quick. So she goes to school that day. She just recently started working at a local fast food eatery called the Burger Barn. She was very excited about receiving her first paycheck. So then she calls her mom. Hey, mom, my check's ready. Do you care? There was also her grandmother would give her rides because her mother worked full time. Her grandmother was not available that day to give her a ride after school. So that was sort of the reason why, or that was the reason why when she was calling and texting her mother, was, hey, will you please let me just walk to work? It's just a quarter of a mile. I'll be okay. It's not that far from home. I'll go, I'll pick the check up, and I will see if they'll give me a couple hours of work and be great. So this is something that Allie's mother, up until that point, there was no, hey, I'm going to walk here, I'm going to walk there. So it's not like she done this all the time. This was a special situation. She was excited about getting her first check. She wanted to pick up a few extra hours, had no ride available. Grandmother wasn't available. Mother wasn't available. So after, the teenage, please, mom, her mother said, okay. And so got off the school bus. She got off the school bus with two other boys that she went to school with. Apparently, they did walk in the same direction. Allie walked a little bit further behind the boys, which apparently through the police interviews, the boys said that's typically normal, that she'd be on her phone texting this person, that person. They did get the records. She wasn't, texting a secret boyfriend or a number that the parents didn't know. So there wasn't really anything helpful on the cell phone part of the deal that could help. So after, they find out she never showed up to work, excuse me, and didn't answer back. The last communication sent out from Allie's phone was at 5:47 that night. So by the time her mother had texted her to answer, there would have not been a response. Excuse me. So mother shows up, 9 o'clock, Burger Barn's closed, it's locked up, no one there. She starts freaking out. So calling the friends, I have no idea. Then friends' parents, I don't know. Got a hold of coworkers, didn't see her. So, they call the police. Police come out, take a report, go up and look in her room, come back out. Well, ma'am, we don't see any, signs of foul play here. So we're going to slug this as a runaway. Do us a favor in the morning. Call us when she comes back. And Allie never came back. But the interesting thing to point out of that is they did not take a report that night. They did not file a report. They didn't even file the runaway. There was no notes taken from that night, no supplementary report, no be on the lookout, nothing. They left, and then it was days later before law enforcement would be back involved in the case again. So that right off the rip, the cops are handling this as a runaway teen. That's the narrative that they went with. So here is a few of the interesting circumstances here that they were able to discover in the investigation. Allie was an avid texter. She averaged 4,000 texts per month and used her cell phone often. Yet all communication, including pinging from the cell towers, stopped at 3:00 p.m. that day. Allie's room was exactly how it was that morning prior. Her cell phone charger, clothes, makeup, money, jewelry, and things that she would have grabbed, to throw in her bag, were in her room. They were thinking if Allie did run away, she would have taken the money, cell phone charger, some clothes, something. Interesting enough, the paycheck that she intended to pick up at the Burger Barn was not picked up. So she didn't even go in and retrieve the check. So she was never there at the Burger Barn. When they interviewed the Burger Barn employees, they claimed Allie never came in at all that afternoon. Excuse me. Allie rarely went out with her friends and loved her creature comforts at home. Her friends would usually hang out at Allie's house rather than her going to them. She liked being in her room. She liked drawing, painting, listening to music, texting, and talking on the phone. Allie was still involved in softball and Girl Scouts and her school choir. She had plans for the near future. She shared these with her mother. She looked forward to helping arrange an Alice in Wonderland party for her best friend's birthday. So she was involved in that. So this wasn't, a deal where she hadn't told friends and family what her upcoming plans were. She had stuff she was looking forward to, and she had shared that with her family, which is important. When you're thinking about people who are desperate and are at a point where they're thinking about making a dangerous change in their life, they sometimes, won't share future plans, don't have future plans. But she did, and she had shared those out. The center that the family contacted that helped sort of jumpstart this into more of a missing of a runaway teen, place called the Lore Recovery Center. When they came in, they took a different approach. They established a command center, coordinated search teams and volunteers, and they searched the area. For 2 weeks straight, they organized and executed awareness alerts, which was flyers, distribution of materials, and conducted searches. Hundreds of searches, including local mounted searches. They organized rescue teams with search dogs, ATV boats, and these were all volunteers from the community who did this. Law enforcement was not involved in that whole 2 weeks of searching. And that 2 weeks of the search, that's pretty much where anything new with the case stops. The only other time a story surfaced anything about this since 2010 was late last year. Her mother had kept Allie's cell phone plan active in case by some means Allie wanted to contact her family, she could. But late last year in December and into the new year, her mother finally had the phone shut off. She had also been involved with some local psychic help. That's a topic for a whole nother stream that we can talk about. But the fact that most of the searches conducted, at least in the first 2 weeks, had no law enforcement presence whatsoever. So when they went out on horses, ATVs, boats, when they did the handing out of flyers, none of it was assisted by law enforcement. They considered this a runaway teen, and that is where the extent stopped until after the first year. And at that point, the FBI stepped in, and then they started putting out the missing posters and alerts for Alexandria. So on the day Alexandria went missing, just off the poster here and also the Charlie Project, 4/26 of 2010, that was the day she got off the school bus. She was last seen in Spring, Texas. She is a white female. She was 16 at the time. She would, of course, I've got some age progression photographs to show too. At the time, she was between 145 and 150 pounds. She had dyed black hair, but her original hair color was brown. She had piercings. She had loved multicolor, kind of cool things like that. But it says here listed on the FBI posted, the Harris County Sheriff's Office is requesting assisting in locating and providing information about the disappearance of Allie Lowitzer. Allie was last seen getting off her school bus on April the 26th, 2010 at 2:44 p.m. The school bus stop was approximately 250 feet from her home. So that it gives you when she got off the bus with those other two boys, I mean, she was very, very close in the proximity of her home. And with those belongings still being left at home, the phone charger, the money. Oh, hey, Michelle, the money, the clothes, the makeup, all that being left at home kind of tells you that even though she walked in the direction of her home, there was nothing that told investigators that she went home first, other than the fact that that was sort of the direction she was walking in, but that also is the direction for the end of their subdivision. So the direction they would have walked coming off of the school bus is in the direction of the exit of the neighborhood that they lived in. And so by the time investigators actually interviewed the other two gentlemen that got off the bus with her, it had already been a substantial amount of time. I'm pulling up some other things about her, and then we'll get to some of the age projection photographs that they did put out. Excuse me. Sorry, I'm catching up on this real quick. Alexandria's parents do describe her as artistic and well-behaved teenager. As I mentioned before, she did enjoy softball, sang in the choir, and was active in the Girl Scouts. From what they say, she was a homebody. One of the interesting things about this case is just the lack of any other evidence that has come out. There's not been, and investigators got into her computer and found that she had a whole another identity, or that she was talking to this guy or that guy. Literally, when she gets off the school bus, she takes a few steps and she's gone. Her parents weren't they were separated at the time of the disappearance, and so she was living with her mother, and of course her grandmother was a big part of her life too. With her mother working full time, she would depend on her grandmother for rides to and from work. Now, you can't really relate it necessarily to the disappearance, but it wasn't but a few months after Allie went missing. The Burger Barn. What's going on, Mr. Sam? I dropped the link. If you want to come up, I'll do that real quick for you. The place that she worked, the Burger Barn, it was ran by a couple from. I'm going to mispronounce it, and it's going to make me look silly. It was a Middle Eastern couple who had immigrated here, and the business was successful. They weren't facing foreclosure. They weren't in any financial dire straits. But a couple of months after Allie went missing, the place closed down and they left the country. And they, other than the initial talking to Allie's mother, excuse me, they weren't suspected or anything, and that's not what I'm trying to say. But 2 months later, boom, they're gone. They leave the country, not made an additional statement since then. That's sort of the only kind of weirdness factor as far as things that happened right after she disappeared that has come about this case. The psychic that was assisting her mother did some things that made me very uncomfortable when I was talking with her mother, as far as she going to her and saying, Hey, I feel your presence. I feel her, that she's in just so much danger right now. I feel she's progressing me with fear right now. She's kind of feeling up. I'm not saying building up false hope, but uh, kind of, I believe, taken away from what could have been something a little more substantial. But literally, she gets off the school bus. She goes less than 250 feet and has not been seen since. So, for the sake of getting this out here, I would like to show the official time released age progression that they have on her, because she was 16 at the time that she disappeared, and that was in 2010. So I will get that pulled up here, and then we will move on to our next topic, which will be some, we're going to talk about, we're going to get into, excuse me, well, sorry, there we go. We're going to get into, there we go. That is the official 2023 age progression photo of Allie. And if anybody watches this video in the future or whatnot, and they have any information on the whereabouts of Allie or what may have happened that day, please contact the Sheriff's Department in Texas, or the FBI, but you can get a hold of them at 713-274-9247, or at the FBI at 800-634-4097, and that can be done anonymously. All tips, if you want to call it in on the anonymous line, will stay anonymous. If you have any information on what may have happened to Allie, or if you have any information that could lead to helping further that case along, if you'll contact them at those numbers I said, I would, it'd be great. So we are going to keep moving along on topics here. So let's say, and again, I'm not, this ain't about a specific case. I'm not bringing up a specific person. Just some things the last couple of days that has been sort of going around is, let's say you one day you get a letter in the mail and you're getting sued. So one thing you want to do is you want to go out and you want to get an attorney. You want to find out what's going on. You want to understand what you can do. So you go out, you get a attorney. You share the case with the attorney. You answer the rule of, excuse me, and your attorney, they passed the bar. They've got years of experience working either for the county or the law firm that they're working for. Being a lawyer, it's I mean, you have to pass the bar for a reason. It's not easy to understand, let alone the law of a specific variety, but then the court proceedings and how to file motions, how to properly understand the process of evidence. And, Hollywood has done a job of, reenacting some famous scenes in court. The you can't handle the truth moment, mind you, comes up, or for us old heads, the Perry Masons of the world, slap an objection up there. Hey, hey, if he can figure that out, hey, maybe I can too. But anyways, let's say someone out there, you or someone they get sued, they get an attorney. You go through the process, you file the motions, you answer the questions. Now, we're talking civil, we're not talking criminal here. There is two separate sets of rules for when you go on a civil case versus a criminal case. Casetext.com is a site that is really, really good on answering some questions to that extent. So let's say you're getting kind of down to it, and all of a sudden you decide, or your attorney decides, that you want to separate yourself from each other, the case. Now, excuse me, the representative in the case, he can terminate his representation. There's two sets of rules for the client and the attorney. Excuse me, when it comes to the withdrawal of your legal representation from a case. All right. So we're going to talk about what the rules are for an attorney when he decides to terminate his representation. And then we're going to get into what I got to talk with a circuit court judge about this very topic, on the topic of in civil court having a change of representation to not necessarily another attorney, but representing yourself. And I'm going to get into some of the things that he told me. And so there's a rule. It's in most states, it will be like a 1-16 type thing. In certain states, Tennessee, Colorado, Florida, the verbiage is very similar in each state. Basically, except as is stated in paragraph C, a lawyer shall not represent a client, or where representation has commenced shall withdraw from the representation of a client if, and then here we go, the representation result in a violation of the rules of professional conduct or other law. Basically, the lawyer's rules of professional conduct, and or it breaks the law. So there we go. Number 2, the lawyer's physical or mental condition impairs the lawyer's ability to represent the client, or now that would be conflict of interest, or the case has taken an extreme mental or physical toll on the actual lawyer itself. But that's what that is. And number 3, or the lawyer is discharged by a client. Now that the client can just pop up at any time, boom, you're done. As where if you're an attorney, it's a little different. You've got to go through some filing some motions, and then it has to be approved by the judge itself. Next, on B here, a lawyer may withdraw from representing a client if 1, withdrawal can be accomplished without material adverse effect on the interest of the client. So if, let's say it is a divorce, the lawyer files his motion for separation, and it most of the times will say something to the extent of the communication between parties is not working out. That in some legal language, that's most of them say. I have seen one earlier today that stated that there was some issues with the client in open court saying that I'm just not going to pay. So they ended that in there. But most of the time it will say something to the extent of, hey, the communication between us is not where it needs to be. But let's see. Sorry, I'm doing a little a back end thing here. But yeah, the link's out there. If anyone wants to come up, unless I'm doing it wrong here. Give me a second, guys. I'm sorry. I'm still not too swift with StreamYard here. All 3 of my people here. There we go. Okay. So let me get back to this one. As I said, it cannot be accomplished without material adverse effect and interest on the client. 2, the client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. That's pretty much self-explanatory. The client has used the lawyer's services to perpetrate a crime or fraud. I think we'll just go ahead and highlight that one real quick while we go on. The client insists upon taking action that the lawyer considers repugnant or with which the lawyer has fundamental disagreement. Number 5, the client fails substantially to fulfill an obligation to the lawyer regarding the lawyer's services and has been given reasonable warning that the lawyer will withdraw unless obligation is fulfilled. What that is let's say you don't pay for a bill that the lawyer comes into you for, and then the lawyer gives you a written notice or on your monthly statement that the lawyer gives you that he has to give you, will say, hey, if you don't fulfill your financial obligation, I will withdraw myself from the case. Most of the bills or statements that you get from your retained attorney will include that in there when you enter in to a contract with them. Number 6, the representation will result in an unreasonable financial burden on the lawyer or has been rendered unreasonably difficult by the client or other good cause for withdrawal exists. That number 7 is put in there just, for whatever reason that the lawyer wants to put on there. Again, it has to be approved by the judge. But here we go into this in the subsection C. A lawyer must comply with applicable law requiring notice to or permission of tribunal when terminating representation. When ordered to do so by a tribunal, a lawyer shall continue representation notwithstanding good cause for terminating the representation. Now that means is, let's say the judge might say no, that whatever cause is listed in that, the judge might see that as detrimental to the client, and he can say, no, you have to continue representing this client. So that's pretty much what that is. Excuse me. Upon termination of representation, a lawyer shall take steps to the extent reasonably practicable to protect the client's interests, such as giving reasonable notice to the client, allowing time for employment of other counsel, surrendering papers and property to which the client is entitled, and refunding any advance payment or fee or expense that has not been earned or incurred. That means part of a retainer that's not been used up. A retainer, when you go into a lawyer, they're going to give you an estimate of this is what the whole job's going to cost. So that's your retainer fee up front. If you're doing this in a civil matter and you're not just retaining a monthly client as a corporation. So they're going to give you this estimate of the case, right? So you're going to pay that out. And then if the lawyer withdraws from the case, at that point, he's legally obliged to give back what portion of the retainer was not used up. And that goes to the court with the statements. Those statements, monthly statements that the lawyer gave the client, has to be presented with the motion of dismissal. That way it can be put in there. This is how much exactly the client is to receive out of that retainer that was not used on the billable hours. Okay, and then this last line here is the lawyer may retain papers retaining to the client to the extent permitted by other law. This, when I was talking to the former criminal attorney, he said that there have been cases where, excuse me, attorneys have had to keep certain things from the client to move forward with their case because of non-payment. So it's sort of a, I don't want to say like a security deposit kind of deal, but is you have to make a arrangement if you owe this attorney to get certain things back. Now it can't proceed to evidence to that civil case, but we'll get into what pieces of evidence that is. I'm gonna put the link out again. I know there's not too many people in here, but at this point, does anybody have anything they want to add to the conversation here? As I'm catching up with chat here. There we go. Okay, I was hoping Sam would come up and join us for a while on this. Okay, so I will, for anyone new here, I will go ahead and paste the link again. And anyone's welcome to come up and talk. Just remember to stay cool. Sam, you want to come up here and add into this? It's a good break to stop and have a drink of coffee too, as I'm enjoying cheap Folgers today. This computer is really slow when I'm on too, so I apologize for that. So, and we'll go down. Here is some addition that was adopted into that that became effective on the January 1st of 2008. This is commenting on that lawyer code of ethics that we talked about earlier. That says a lawyer should not accept representation in a manner unless it can be performed completely, promptly, without improper conflict of interest, and to completion. Ordinary, a representation in a manner is completed when the agreed upon assistance has been concluded. And then it tells you where to look up the comments upon that. A lawyer ordinarily must decline or withdraw from representation if the client demands that the lawyer engage in conduct that is illegal or violates the rules of professional conduct. That's important. This rules of professional conduct we're going to get into when we start talking about when clients decide to represent themselves. Because I have heard some people say over the last few days that they aren't bound by the same rules of conduct that attorneys are when they represent themselves, and that is absolutely false. If you go into and this is criminal, this is civil, if you go to represent yourself, again, this is not legal advice in no way, shape, or form, but if you go to represent yourself, you are held to the same standard as an attorney. At that point, you are not seen as defendant. When you step into the courtroom to represent yourself, you are now seen as your representation. The court sees you as that. You are bound to the same rules that any attorney, excuse me, would be. You do have to follow the conduct of procedure when it comes to a courtroom. That is how you can address the judge, when you're allowed to speak, how to phrase certain questions. The rules of professional conduct is there to help a court case proceed. If you go in there and you do not know those rules of professional conduct, let me have that banner, excuse me, then you're not doing yourself any service whatsoever to the to your own case. I don't really understand in any situation where an attorney would be just okay after he's prepared a defense or a case for you, that he would just say, I think it's a good idea for you to do it yourself. Because just on those rules of professional conduct, if you're not a lawyer, chances are the only rules of professional conduct you are going to know is what you have seen either on a movie or TV. And that is not going to work out in your favor if you try to cross-examine a witness and you just ask a regular question. Whatever, the other attorney is going to hear that, and they're more than likely going to get you on a technicality. There's a reason why a case works in a certain way. You still have to file those motions. When the paperwork that comes in, you still are responsible for that. And if you think you're not responsible for that, then the first piece of motion that comes through that you do not answer, just as if you are a lawyer yourself, at that point, the judge has every right to make a ruling for the other side just on the fact that you didn't know how to answer. The defense of I didn't know what I'm doing, I don't know what I'm doing, does not fly when you are standing in front of a judge representing yourself. Daryl Brooks can probably speak on that himself when he tried to represent himself, and we all seen that, how that worked out for him. I'm not saying it's impossible to represent yourself. There's a lot of, probably more than a handful of examples that people can point to say, well, unknowns, what about so-and-so? Well, okay, that's great. But, I don't really understand a lawyer that would say that to a client, number one, unless he was being asked to do something that was against his code of conduct, whether that's a financial code of conduct or the client's asking the lawyer to do something that is fraudulent or illegal. Don't know. Those, we just went over the rules of what the lawyer has to play by when withdrawing from a case. And then once a lawyer is withdrawn from the case, he's withdrawn from the case. Unless the defendant goes or the person, client, goes back in front of the judge, can that attorney then be involved in the case again? He would have to go back in front of the judge and say, hey, he was my representation, he withdrew, I want him back. And at that point, the judge has to approve it or not. And that's the standard in that situation. So I think that's something to keep in mind when you hear people talk about, hey, they're built to go represent themselves. Excuse me, not necessarily the why attorney this, why that. Attorneys can withdraw themselves under those reasons we just listed before. It's not just it has to be initiated by the client. That's not true at all. Those reasons we listed, they can go in front of a judge and file the appropriate motions. And then at that point, once the judge approves it and the paperwork is then handed back to the client, at that point, they're done with it unless the client goes back in front of the judge to have it reinstated as legal counsel. I had to look for that word. So, okay, so we're moving on here. The client has a right to discharge a lawyer anytime with or without cause, subject to liability for payment for the lawyer's services. Where future dispute about the withdrawal may be anticipated, it may be advisable to prepare a written statement reciting the circumstances. That's sort of what we just said. The client does have a right at any time for any reason, with or without cause, to drop their representation. Of course, when an attorney is the one that initiates the separation, they have a certain guidelines they have to abide by, and that's what we just went over. Whether a client can discharge appointed counsel may depend on applicable law. A client seeking to do so should be given a full explanation of the consequences, and that's how they word it. These are consequences for your lawyer separating from your case. These consequences may include a decision by the appointing authority that appointment of successor counsel is unjustified, thus requiring self-representation by the client. So the judge can pretty much make it to where, hey, we're not letting you have an additional time to find an attorney. We're going on and you have to represent yourself. So that is a consequence of having your attorney withdraw from the case, is the judge says, hey, you know what? I'm not giving you any more time. I'm not giving you another chance. We're going on and you have to represent yourself. Excuse me. If the client has severely diminished capacity, the client may lack the legal capacity to discharge the lawyer, and in any event, the discharge may be seriously adverse to the client's interest. The lawyer should make special effort to help the client consider the consequences and may take reasonable, necessary protective action as provided in the 1.14 permissive withdrawal. And we'll talk about that in a minute. A lawyer may withdraw from representation in some circumstances. Here we go, talking about, like we said, there's different rules that apply from when the client initiates it, from when the attorney starts it. The lawyer has the option to withdraw if it can be accomplished without material adverse effect to the client's interest. Withdrawal is also justified if the client persists in a course of action that the lawyer reasonably believes is criminal or fraudulent. For a lawyer is not required to be associated with such conduct, even if the lawyer does not further it. Withdrawal is also permitted if the lawyer's services were misused in the past, even if it would materially prejudice the client. The lawyer may also withdraw where the client insists on taking action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. I think that pretty much is self-explanatory as far as that goes. A lawyer may withdraw if the client refuses to abide by the terms of the agreement relating to representation, such as an agreement conferring fees or court costs, or an agreement limiting the objectives of the representation, assisting the client upon withdrawal. Here we go. There's where we go to about assisting clients upon withdrawal. I said earlier, like when that withdrawal happens and the judge approves it, you can't just have him do things for you unless you go back in front and get that reapproved by the judge. Even if the lawyer has been unfairly discharged by a client, a lawyer must take all reasonable steps to negate the consequences to the client. The lawyer may retain papers as a security for a fee only to the extent permitted by the law. That's what we said earlier with, yes, they have to give you back the case files, but the lawyer may keep certain pieces of that as long as it is approved by the judge. If it is a situation where the lawyer feels like they are not going to get paid anything for these services. So that is sort of a way of having a little bit of security against the client when this happens. So that is the case text as far as the statute for how your representation can withdraw from your case and what that means as far as the repercussions going forward. It's basically now, you say your lawyer's done that, it's up to the judge now. He could rule it in a couple of ways. He could approve it, and at that point, the lawyer's withdrawn. Judge may say, this is not valid enough reason, so no, I'm not going to approve it. Or the judge could approve it and then say, okay, now you're going to move forward and represent yourself, depending on what reason that is that was given for the withdrawal. That's what's in the judge's ability to rule on this. I'm not saying that he will. I'm not saying he won't, or they will, or they won't. That's just saying those are some of the options on that going forward. So there you go. There is the some of the those are the guidelines for lawyers withdrawing from cases. I thought that it was an interesting topic, and I thought we would look at some of the actual legal letter because there's a lot of things flying around about that lately. And again, I'm not getting anyone specific. It's just that is sort of the thing going around. So before we move on, anybody in the chat have anything they want to bring up topic wise, anything they want to plug or talk about? Anybody got any upcoming videos or lives or anything they want to bring up before we get into the next topic here of self-representation in court? Give it a second to see if anybody says anything. Because I got nobody in the waiting to come up, so and got nothing in chat. Anything in chat? jump down here. There we go. YouTube rejected your comment. Man, this happened a lot. I try to make comments and then I get a thing. This says YouTube rejected your comment. This usually means they think it's spam. Try changing it a bit. There we go. It approved that one. We'll let anybody that wants to add anything to it. If they want to say anything. I don't know what the deal with StreamYard is doing right now. Sorry, guys. One second, I am getting some new stuff for the screen here. One second. Okay, I guess we will go forward then. No one is going to come up. Okay. And some other possibly boring topics. This talks about representing yourself in court. You know, as we said earlier, there is risk with not understanding court proceedings and the rules when it comes to going in a courtroom. It's not all like A Few Good Men or your favorite reality court show. He is the father or he isn't the father. When it comes to representing yourself in court, there are risks to representing yourself. Now, this site here is a site where it tries to, it's a civilian law help center, and sort of gives you some risks and tips. So let's, I mean, you would think, you know, this is kind of risky representing yourself, especially, I mean, you may know your case inside and out. You may know your evidence inside and out. You may see that the people that you're against, you've seen everything that they've got, and you think, well, that's, you know, I've got the answers to all that. But then you get in there and you say one thing wrong, then next thing you know, the case is either you throw it out or you're getting ruled against, and you have no idea how quick that happened, and your head is spinning. So the thing about it, the big icing here on the thing cake is that you need to understand that you are required to follow the same procedures as if you were a lawyer. You don't get any special treatment because you're representing yourself. You are going to be treated as if you are a barred attorney, the representation. You don't get treated any different. You don't get any slack. You don't get to use the excuse of, I didn't know, I'm representing myself, I have no idea I was supposed to do that. You don't, that doesn't fly. That would immediately get a ruling against you. So, you know, if you are going down the path of representing yourself, you better do your homework and you better take real good notes, because it's not a easy thing. Just because you have the gift of gab and you can talk, don't matter in the court. When you're standing in front of a judge and you are not following the right procedure, it could end all that hard work just like that. Oh, it's okay. It's okay. It's your late. It's all right. It's all right. I was hoping some other people would want to come up and talk, but we're on the topic now, representing yourself in court and some of the risks involved in that. But yeah, like I said, you have no excuse as far as I didn't know. That doesn't exist. You're not getting any special treatment. You need to go in there and, like I said, act as if you are the attorney, because that is how you're going to be viewed, because you're not going to be viewed as the defendant at that point. Excuse me. You're going to be required to know how the chain of evidence works. You're going to need to know every piece of that evidence front and back. You're going to need to know how the procedural court goes, what the terminology means when judges say this or the other attorney is cross-examining and they say that. You're going to stay on top of that. You're going to have to know how it works from point A to when everybody stands up, when they say everybody rises until the gavel clangs down. You're going to need to know that procedure. So that's why it is a big risk when you try to go and represent yourself, because in these civil matters, even in criminal matters, if you represent yourself in criminal court, one wrong thing, you say one wrong thing and you think you're doing the right thing, and you have either gave the other side the opening that they need, or the judge is going to absolutely look at you and just be like, nope, want to rule in the other side. Boom, gavel goes down, and then like your head's going to be spinning. You're going to be like, what did I do wrong? I knew my stuff front and back, and yet, but that's the risk you take when you do that. And then if you try to go in saying, well, the reason I didn't file this is I didn't know how. That again doesn't work in the judge's eye. In fact, the pre-hearing stuff is the most important stuff, because you have to answer these motions. You have to answer the claims levied against you. Again, if you say, I didn't know I was supposed to do it, I didn't know how to file this, I didn't know how to do that, it's over. And it's not just getting thrown out, it's getting a ruling against you before you've even stepped in the courtroom. So it's a big task, taking on the mantle of representing yourself in the court. It's just the terminology alone, just knowing the vocabulary that you have to use in court. You might think you're saying something, and it comes out of your mouth. Judge, bailiff, everybody starts looking at you like, whoa, what? So, and then if you've never cross-examined a witness before, if you've never had that experience, that's why it's so hard to become a lawyer, because it is hard to go in and procedurally break down and defend someone in the court and to take on the mantle of representing a client. We have an objection from the chat. So, just like this site is getting into one, let's say you do everything right as far as you're filing your motions. You do somehow get to that point where you're ready to start. You've filed the right motions. You've answered the right this and that. You get there. Now there's a whole nother world of technical requirements that you're going to have to prove your case and establish your cause. That's what this site says. So if you lose your case, the judge could order you to pay for the other side's court costs and attorney fees, in addition to whatever other money the side is suing you for. This is true whether you are suing or being sued, and this could be a lot of money. Sometimes the costs of suing are more than the amount sued for. If the judge orders you to pay the other side's fees and costs, a judgment will be rendered against you. So, hey, if you're in there and that happens, there's not going to be another comeback to the court. The judge is going to enter that judgment against you right then and there. And as it says here, it's valid for up to 6 years and can be renewed for another 6 years, as many times as necessary until a judgment is paid. to collect judgment. The other side can garnish your wages, thereby your bank accounts, place liens on your property, and utilize other collection methods. That means they can slap something against your plate. Like say if you don't get a regular paycheck, they can come in, they can valuize your property, they can take every bit of property and give you like literally pennies on the dollar on what you think your property is worth and possessions inside of it. They will literally come in bit by bit and take everything you have. And it can happen in a blink of an eye when you go in, especially if you're going in and you go into that courtroom to try to represent yourself. So that is a big deal. If the judge orders you to pay the other side's, sorry, I didn't read that. So think carefully before you decide to sue someone or represent yourself in your case. If you lose, instead of winning money or some form of relief, you could actually owe the other side money. And so they give you a checklist here to evaluate whether it is a good idea for you to represent yourself or not. I have a complicated case or a case that might become complicated. That's number one. I do not feel confident that I can express my ideas and thoughts in writing. I'm not usually on time and have a hard time meeting deadlines. I want or need legal advice. Like that should be like if you have to check that box right there, jack off objection overruled and you're sustained. How about that? But anyways, if you check that box, I want or need legal advice, that should be your glaring lie that don't do this by yourself. I'm not available during the day, during business hours. It will be difficult for me to arrange time off and daycare during the day. I do not believe I will be able to stand in front of a judge and explain my position. I'm not comfortable doing research in a library or on a computer. I'm worried that the other side will not play fair or game me. I get angry easily, especially when I am under stress. I am often frustrated by rules that I think are unfair and I should not apply, and they should not apply to me. I might be too close emotionally to I could go on reading this, guys, but it's the same thing. Like these are the checklist of things that if you check any of these boxes, you shouldn't have no business representing yourself. So if you know somebody, again, I'm not bringing up anybody specific, but if you know somebody who might be, facing some lawsuits and they check any of those boxes, you might not need to be representing yourself. Again, it gives you some tips for if you do decide to do this. And this is easier said than done when it says learning the laws and rules that apply to your case, because I'm guaranteed that just because you think something about your case, hey, it's cut and dry. They're suing me for something stupid. You might not know all the rules involved and laws involved in this particular case. Do not give up without understanding the consequences. If you're being sued and do not believe that you have any defense, you might think there is no point in going to court. This can be dangerous, however, because you might not completely understand everything that the court can or will order in your absence. It is best to get legal advice before deciding to give up. Make sure all your written submissions are complete, neat, and timely. Again, like we said earlier, this "I don't know" excuse, you can't apply that to these court documents. It has to be submitted clearly. It has to be submitted on time and in the right format. It's not just grab your big ballpoint and write out, "I'm innocent. This is why I am innocent." You have to attend all the hearings, and you need to get to the courthouse early. You need to bring all your files, bring your evidence and witnesses. You need to, it says arrange for an interpreter. That's it, I guess, if you're, if you have some foreign language aspects to your case. And conduct yourself properly in the courtroom. Here is a big thing, because there's a decorum in this courtroom. There is a statute of this is how court cases proceed. This is how you need to act to get when it's time for you to give your opening statement. there's certain rules of guidance to that, and it's not just standing up and just blurting out. You know, how do you know when to object to something? How do you know when to intercede? You can't just get mad and pop off. You'll be shut down real fast in that. But so understanding the decorum for a case is super important. But there's plenty of sites out there. If some way you look at this checklist that they give and you still feel the need to represent yourself for whatever reason, there's plenty of sites out there for you, and good luck with that. So again, this stream was for no legal advice whatsoever. I'm just an unknown idiot up here rambling on about things. So now that we've talked about that, I'm going to open up the floor again for anyone who has anything they would like to discuss. If you have anything at all you want to bring up, open floor right now. Anybody want to add anything or discuss anything? Or we will gonna switch to another screen here. And this comes from Matthew and Jones, attorney at law. If we'll stop. There we go. And we'll get that. We'll share the screen. There we go. All right. This is put out. Of course, they are a law firm, so they're going to have advertising. But this has got some really good advice. We talked about some of pros and cons. So from the Matthew and Jones attorneys at law, they put out a little thing. Talks about navigating the court system takes years of education and training. Presenting a successful case in court requires extensive experience. Excessive pressure can make emotions run higher than usual, and then your freedom and future are on the line. So those right there, sum up pretty good to me how I would feel about if I was facing anything, how I would feel about it. But now that we've kind of covered everything, now we can get to some housekeeping items here. Starting next week, the first episode of a new podcast will be coming out. It's going to be fun. It's going to be a good time. We're going to talk about some interesting topics. So when that comes out, we'll be sure to plug it and share it everywhere we can. I really think it will be a good listen. The first show we're going to talk about a few different things. Don't want to spill it all right here, but it is a podcast, but it's also going to have a video element with it. So I definitely have something up on screen to try to coordinate with what we're talking about. So excuse me, it'll be called Unknown Variety. It will have its own channel. So if anybody wants to go out and subscribe to that when the episode comes out, feedback is a good thing, good or bad. So share that up. The series on the Kurt Cobain, I'm not done with that. The next live that we have on that, we're going to get into Courtney Love a little more, how she was acting in the months leading up to Kurt's passing, and then a couple of years after. In the couple of years after that, there's some really head scratching things that were found and were sort of discovered. And then, hey, that Barbara Walters interview she did, my gosh, it's a hard watch in 2024. It's a hard watch knowing, everything that you dug and scratched around in this case to find. It's kind of a hard watch. Well, is she guilty or not guilty? Well, in the court of public opinion, it goes either way. I think there's as many people in the community that believe she has something to do with it than not. Again, I don't have the smoking gun piece of evidence. It's kind of weird that everyone around the case that seems to have that one little piece ends up not being around anymore. There was the whole El Duce situation, which that guy in himself was, wow, what a character he was, man. He was part of a deathcore band, and he ended up being found decapitated by a train not too long after he was spotlighted on a documentary about Kurt and Courtney, where he gives out the name of a guy. And, Courtney came down to the shop and she offered me $50,000 to kill her old man. He did take 2 different lie detector tests. He passed one and failed the other. And he failed the other, they claimed, because he was high on heroin and fell asleep. So, I mean, there's so much smoke around it that I believe that eventually some fire will be uncovered. But then again, hey, maybe all this is coincidence. If you're one that believed in coincidence and, excuse me, a bunch of coincidence, then, hey, maybe Courtney is just playing us for idiots for the attention. So, I mean, we're going to get into that. We're going to talk a little more about that later in the month. On that, I have been talking with another YouTuber who got really invested in the case. His name is the American Spy Fox. Well, we haven't been able to nail down a time to actually talk or get him over here, but coincidences or a cause of death. By there you go. That's a good way to sum it up, Jakov. Death of coincidental misadventures. How about that for some word judo? But it's talking to him, and he was the one that actually got to hold and see the autopsy straight from Kurt's uncle. So he went out to I think it was Aberdeen. I could be wrong. He went out there and did that. So that's going to be coming up pretty soon this month. Of course, we got that. Trying to think if there's anything else, unless anyone has anything else they want to come up with. Again, anybody's welcome to help it along. But okay, well, if that's the case, then I'm going to say my good afternoons to everybody. I know this is a daytime live, and those don't get attended to very much, but I appreciate everybody who came in, who contributed, who listened, and who will come back and watch later. But after that, unless anybody has anything else, we're going to go ahead and shut it down for the day. Well, all right then. I guess this will say everybody have a good Saturday, and we'll talk to you soon.